Hello again. Hello, hi everybody. Hi. Welcome. Hello, Denise, Sally, Carrie, Bruce Wayne's mother. Hello. Hi, Dania. Alan, welcome in. Big Papa. So funny. That's my cat scratching in case you're wondering. Hello, Jennifer, Mama Llama. Delulu, welcome in. Hi, everybody. I am just finishing up. I finished up a pregame show over on the talk earlier, just kind of hanging out with everybody before I came on tonight. But of course, Tuesdays are my YouTube night, so Tubing Tuesdays. So here we are again. Hello. Nail cam. Here we are. These are kind of just for fun tonight. I thought, well, I needed a little extra something fun. So these came together pretty nicely. I thought they were pretty fun. From Florida, hello. On time, yay! For sure, welcome. Yes, good evening to you too as well, Nancy. Oh, thank you so much. Thank you. I appreciate that. Yeah, we got some crazy from Oregon. Oh my gosh, hello. I'd love to go to Oregon. I've heard it's gorgeous. We got some weird stuff going on today, but not too much. So that's kind of good, right? As long as it's not too much, we can handle it, deal with it. That's what I tell myself. Just don't have too much and we'll be all right. I'll just keep telling myself that. All right, hold on here, everybody. Just double checking to make sure. Oh, wow. Musk is really getting himself into some trouble, isn't he? Well, who could have predicted that? Us, we did. We predicted that. We knew that was going to happen. Oh, thank you so much, Vance. Appreciate that. So welcome in, everyone. I'm so thankful you could come by tonight. We have had a few interesting things going on. I've done some posts. I make sure that everything I'm posting over on the talk, of course, I am posting here. I am for sure making sure that I am here as much as possible. I do prefer the tube to the talk, so I am making sure, again, to make this I'd like to make this again my primary place, and I'm working on it, so we'll try to see what we can do to get that sorted out here. And with that, so yes, made it, yay! Really on Thursday. Oh, love it. Hello, Mishgish. Great name. My goodness. I love it. Oh my gosh. All right, well, let me get a little bit closer here so everyone can see what I'm doing. And here we go. Let's get professional here, everybody. I'm slacking off. Here we go. Hopefully, if anybody sees John, just make sure, he's not been caught in a tornado, all right? Yeah. All right, well, welcome in, everyone. Welcome in. We have had a lot of stuff going on, but I've been doing a lot of updates, so I wanted to make sure tonight that we kind of went through what happened with the Supreme Court yesterday. So June's the big month where we get all of our cases from the Supreme Court. Well, we're supposed to, because they want to go on break, right? So their break goes until October. And I'll tell you right now, there's no way this SCOTUS isn't going to be coming back constantly to try to sort out the rubbish in this administration. And I'm wondering how the justices are going to feel about having their schedule jacked up because of all these cases they're going to have to come in and talk about and work through. So I think that's going to be a big piece. We're going to be seeing quite a bit. Not populating on TT. I'm not sure what's going on over there. But it's kind of been a different situation. But we're in all of the places. Although I do have to admit, honestly, I do enjoy the tube. I enjoy it a lot. Yeah, no vacations for them. So Thomas is gonna get in his, big camper and be called back in. Like, you can enjoy that. Right, exactly. So let's take a look here at what's been going on. This was just yesterday, and we can just go through and see what's been agreed to, what's not been agreed to. So there's been a lot of discussion about all of this. Let me grab my highlighter here. On recent Massachusetts 1,500 ICE captures of illegal immigrants. I don't have an opinion yet. I have to look into that a bit more. Did have a tornado on the ground, traveled south. All right, missed our homes. Oh my gosh, John, take care of yourself and your family. Oh my goodness gracious. Woo! All right, here we go. And we're going to dive right in so we can entertain you, John, as you go through this storm. Here's the first one. So we have orders in pending cases, which is exactly what it means. It means there's a case that's been pending. They'll let us know what the decisions are. Then they'll go through and tell us which certs have been granted and which certs have not. Yes, this live is separate from TikTok. This is the tube on Tuesdays. So this is a separate world here. First, we've got the Slaughter v. Board of Professional Responsibility here. Motion for leave to file a petition for writ of cert with supplemental appendix under seal is granted. So I don't really know too much about this case, but if we have a Board of Professional Responsibility involved, we're going to have some kind of an ethics complaint. So somebody has an ethics issue going on and they wanted to file additional information here. Next, what is this? Agudas, Chesidai, Chabad. Oh my gosh. Versus Russian Federation. Oh dear. That's like the country here. The Solicitor General is invited to file a brief in this case expressing the views of the United States. Justice Kavanaugh took no part in the consideration of this petition. Justice Jackson took no part in the consideration of this petition. Interesting. See 28 U.S. Code, Section 455, and Code of Conduct for Justices of the Supreme Court, Canon 3B2E, prior judicial service. Ooh, that's interesting. So what they're saying is Jackson and Kavanaugh both withdrew, recused themselves, because they had somehow been involved in some piece of this case before. So they're down 2 justices. They've only got 7 justices here. But look at this, everyone. We love this. They're citing the ethics code for the Supreme Court, right? We love that. We love to see that. Good for you. I'm not going to give you too many props because, you know, you've got problems. But that's pretty great. So they are saying, look, we're recusing because we have a code of conduct for the justices of the Supreme Court. I think that's great. Yeah, I think that's great. All right, so the Solicitor General is invited to file a brief expressing the views of the United States. That's interesting because they're asking the government to file a brief. And as we know, the Solicitor General, is that what was that guy's name? Can't remember. Oh, I forgot the name. Well, anyway, he was that criminal defense attorney, right? Oh my gosh, everybody. I forgot his name. That's about, yeah, exactly. Sawyer. I think that's right. I think it's that Sawyer fella. So they're saying, hey, do you want to file something to tell us what your opinion is? I think it's Sawyer. Yeah, Bove, I think's in the DOJ stuff here. Let me just double check. Actually, let's look it up. If only we had the capability of looking up who the Solicitor General is. Oh, look, I've got a computer. All right, here we go. Let's just make sure. Yeah, it's Sawyer. Oh my gosh, whatever. It's that guy. Oh my goodness. Yeah, so that was okay, thank you very much. Yeah. All right, so they're like telling him, dude, there's this case. Do you want to like, you know, do a brief or something? Like that's yikes. All right, next up, Duke Energy Carolinas versus NTE Carolinas. We don't know what's going on with that. Hertz versus Wells Fargo. Solicitor General is invited to file briefs in these cases expressing the views of the United States. So is the SCOTUS telling the Solicitor General that he needs to like do his job? right? That's what this feels like here. Let's just be like, interesting. Next, we've got Sign Troy versus Bank of American National Association. Don't know what that one is either. Seems like they are, I know, right? Okay, and then Yeola Ganiyu versus Garmin. Motions for petitioners for leave to proceed in form of paupers are denied. So they're saying pauperous, that means they are unable to afford their litigation fees. Petitioners are allowed until June 23rd, within which to pay the docketing fees required by Rule 38 and submit petitions in compliance with Rule 33.1 of the rules of this court. So basically they filed a petition but didn't pay the fees, and they're saying, hey, can you waive the fees? And the court's saying, no, we cannot waive the fees. Right, exactly. Yeah, I think it's weird. All right, so there we go. First page of what was going on with that. Now we've got cert that was granted. We have to be, this always worries me whenever they grant cert. So the first one is Boast here versus the Illinois Board of Elections. So we've got an election laws case. Now, anytime there's an election law case, I would highly recommend swinging over to a democracy docket, because I tell you what, they are on top of the election law situations. So recommend heading over there if you're wondering what that case is about. Next, we have William Case v. Montana. We don't know what that is, but that's been granted. Geo Group versus Menacol Alejandro. Petitions for writ of certiorari granted here. We don't know, again, what this case is about. Hensley Winston versus Floor Corp. Motion of Center for Military Law and Policy for leave to file a brief as amicus curiae is granted. Petition for writ of certiorari is granted. That's interesting. So we've got a military question going on here. Not that the case is military, but the military is asking to file a brief. That's interesting. Really, private prisons. Oh, very interesting. All right, so these were the certs granted. So 1, 2, 3, 4. So we've got 4 certs granted. And then now, look at this huge list of denied here. So let's just see if anything looks familiar in here. I'm sure it won't, but we've got Porats v. U.S., Baker v. U.S., Bolos, Wheeler, Neadors, Erie City Board of Elections. So this is another elections case that's been denied. So I don't know what the issue is there, but sometimes when the court denies the case, it really shows you where the court's at on stuff. So by denying, they're saying the lower court decision can stand. So it's very important to see which ones have been denied, because now we've got precedent in the lower court. So this has got some kind of an election law piece to it. Mount Clemens, Gym 24/7 Fitness, Sullivan v. Texas Ethics Commission. We got another ethics case here. Do they have ethics there? I'm just curious. Turo Tire versus Toyo Tire. Alpine versus Financial Industries. Hold on. Industry. Oh my goodness. I don't know what happened there. Oh my gosh. All right. Lozman versus Riviera Beach. I was reading and speaking too fast at the same time. Crawford versus Kane. No, I don't know that one. Vietti versus Welsh and McGow here. I don't know what that is. It could be a law firm, but it might not be. You don't know. Parker v. Burns has been denied. Plummer v. Kaiser Foundation Hospital. McVie versus Perez. John Baptiste versus Department of Justice. Ooh, that could be a big one. What's going on with that one? This is a DOJ case, and they're denying cert on that. That would be a good one to take a look at and see what's going on there. All right, and then we've got John Doe v. Tennessee here. All right, so again, we'll continue on with the denials of cert. Now, again, I'll go through this, and then what's happened is for some of these denials, the justices disagreed, and so they wrote why they disagreed with that denial. All right, next we've got Haas versus Deutsche Bank, which was in the Trump case, right? Rhodes v. Gifford here. Antonaki versus Emmanuel. Joshi versus U.S. Mona versus Microbot Medical. That's interesting. Shoup versus Indiana here. Clardy versus Nelson. I-10 versus Los Angeles County. Davis versus Cool. Pasternak versus U.S. Lee versus Thornell. Stump versus U.S. Lindsay versus U.S. Hunt v. U.S. Thomas versus Quick Trip. Jimenez versus Dixon here. M versus Illinois. Wendell versus Florida. Rowell versus Adult Representation. Oh, that's interesting. Romig versus Britain. I'm not sure. Right, so what is cert? So certiorari, or what we call cert here, is the document you need to file in order to get your case in front of the Supreme Court. So, we have different names for different kinds of filings, right? You have a motion, you have a complaint, an answer, and so on. Certiorari means that you specifically want the Supreme Court, to review what your issue is. There can be lots of different kinds of writs, right? So we have, it's actually called a writ, and a writ just means, a document filed. Certiorari means you want to be heard. Habeas corpus means bring me in front of the court because I'm being illegally held. Writ of mandamus or mandamus means a public government person is doing something wrong and you need to stop them, or alternatively, they're not doing something they should do and we want to make you do that. So these are some examples of writs. So the cert writ is, boom, I want you to hear our case here. We've got valid grounds for a case. All right, does that make sense, everybody? So certiorari versus habeas corpus versus mandamus. There are other writs, but those are the top three by far. All right, so Newsom versus Dixon, Rivers versus Smith, Wiggins versus Guerrero, Texas. Wow, Texas has a lot in here. All right, Hammersley versus Wisconsin, Goldsboro versus Florida, Hall versus Michigan, Taylor versus Horn. On the birthright citizenship case, the birthright citizenship case is really about injunctions and whether or not they can be for the entire U.S. or only for a circuit. That's really what the case is about. The merits of that particular case, I don't think we're actually going to find out about it for a while. You betcha. All right, Sloan versus V here. Berman versus, again, I'm looking for cases that we may know just off the top of our heads here. And then also there'll be cases pulled by the justices that we'll go through and read why they were upset cert was denied. Berman versus Modell, Duncan v. Curators of University of Missouri, Mejia versus Warden, Shorowski versus U.S. I couldn't ever do names during graduation, everybody. I really couldn't. House versus U.S. Cooner versus U.S. Vargas Velez versus U.S. Ador Sinabel versus Cop Sup Sing Sing. All right. Padilla versus U.S. McGarley versus Sproul. Rodriguez versus U.S. Owen versus Warden. Bowers versus U.S., Sutton versus U.S., Sotelo versus U.S., Ashford versus U.S., Brito v. U.S., Kennedy versus U.S., McGee versus Louisiana, Gonzalez versus U.S., Oakley versus U.S., Boykin v. U.S., Adams v. U.S., Palacios de Paz versus U.S. Oh my gosh, I'm going to say that wrong. Nguyen versus U.S. I know I'm saying it incorrectly. Apologies. Barnes versus U.S. Vasquez Lindever. versus U.S. and Losa Silva versus U.S. Again, these are all denied cert here. Were writs of mandamus frequent before the Trump administration? They were a bit rare, and quite frankly, even during the Trump administration, they are not utilized excessively. They're more frequent than what I've seen before with in recent times. But the writs of mandamus were really what they used kind of in the beginning to get the courts sorted out a little bit, to make sure, because with the new government, nobody really knew what everybody else was doing. So they were kind of using them as a way to kind of check things. So probably the big push for the mandamus was at the beginning, the first like 25, 50 years, and then around 25 years around the Civil War era. And we just haven't hit those numbers again yet. So it's not huge what's happening here. It's more, again, I've seen it more frequently than I've seen it before, but not excessively. Yet, not, we're only 4 months in, so I reserve the right. Yikes, I believe it's pronounced Mayan. Okay, thank you. Looked into DOJVNC and the Board of Elections. I have not, but I do know the democracy docket, I believe, is covering that for sure. Mandamus, I think so too. Mandamus. Let me make sure I'm getting all the questions here. I mean, all approved certs would have to be reviewed. Yes. So when they approve a cert, it goes on the calendar, right? So like we're waiting right now for decisions on cases where they granted cert and heard oral arguments. So they will go through whatever certs they've granted and then sort out how they want to do their calendars. We've only got 4 here. They get a lot of certs, they get a lot of requests every year, but they have a very small number that they actually listen to. All right, Cazares versus Johnson, Ramirez Zermeno versus U.S., Reyes Tafola versus U.S., Trials versus U.S., Velasquez versus U.S. Any of these could be habeas cases too. Lopez v. U.S., Harris versus Fraunheim, Johnson versus U.S., Ness versus U.S., Gonzalez, U.S., Graham, U.S., Flint, U.S., Wilkerson. I'm not recognizing any of these cases as any of the ones that I have followed. So Beck here v. U.S., Jackson versus U.S., petition for writ of certiorari are denied. All right. Also for down here. So now they're going to make a big, showy business here of the certs. So we've got Ocean State Tactical versus Rhode Island. Petition for writ of certiorari is denied. Justice Thomas, Alito, and Gorsuch would grant the petition for writ of certiorari. So that gives you some idea of how the case would probably fall here. If we look and see, oops, that's the wrong one. Here we go. Let's get our roll call out here. Here is the current Supreme Court, right? So just to give you some idea of what's going on as we go through and talk about who is agreeing or disagreeing with granting or denying cert. So if they're agreeing to hear a case, if it's a cert case, it will have to be pulled in off of a cert. What will happen, though, is they pick the ones that they think are very important, right? And the question that they really need to resolve so that we don't have multiple splits in our circuits, right? So if every single circuit answers a question differently, they're like, wow, this is a mess. So they'll come in and try to answer that question on a case. Sometimes they'll deny cert because the question's good, but the facts are bad. Or, the facts are really great, but the question's really bad or poorly written. So there's lots of different reasons for accepting and denying cert. But we have here Sotomayor and Jackson and Kagan are probably seen as the most liberal of the justices. And then we have Thomas and Alito, the most conservative. Then next for conservative would be, Roberts and Barnett are full swingers. And then Gorsuch and Kavanaugh are pretty much to the right. So they are pretty strong on the right. So, you know, Justice Kagan can swing to the right a bit, but that gives you just an overall idea here. So we've got, in this situation, they're saying Thomas, Alito, and Gorsuch would grant the petition for cert in this case. So just again, to get some idea, Alito and Thomas ever disagree? Sometimes. I think Thomas goes a lot further than Alito. Alito's like, I'm busy. And Thomas is like, let me write another dissent. You know, kind of that situation. All right, Atrium Medical here versus Barb. We've got Justice Alito took no part in consideration or the decision of this. So Alito's like, I'm out. Let's see. Lettieri versus Suffolk. Suffolk, where's that at? I should know that, but I don't. Motion for a petitioner for leave to proceed in form of papyrus is denied. So again, you know, can I file without having to pay the fees? And they're saying no. And the petition for a writ of certiorari is dismissed. Oh, ouch. That hurts. Okay, I guess they do have habeas in a different section. All right, well, that's comforting. I was worried that some of those certs were habeas. My bad, my bad. New York, yeah, it sounds about right, doesn't it? Virginia, oh yeah, Virginia, that could be. You made it, yay, welcome Lex. All right, so habeas corpus. So here's another kind of certs. I'm sorry, another writ. These are our habeas cases. Here we've got In re Kevin denied, and we have In re Babu Baya Patel. Babubat Patel. All right, so motion for petitioner to proceed form of papyrus is denied. Petition for writ of habeas corpus is dismissed. Ooh, and then there's more. If there's more, that's not good. The court's got something to say. As the petitioner has repeatedly abused this court's process. Holy buckets, Batman. The clerk is directed not to accept any further petitions in non-criminal matters from petitioner unless the docketing fee required by Rule 38A is paid and the petition is submitted in compliance with Rule 33.1. And then they're citing the Martin case. Holy buckets! Wowzas! I've never seen that before. I've never seen the court. Oh my gosh. Wow. So apparently this is really frustrating. Oh, it's too high. All right. Let me know. Gotta tell me. There we go. How's that? Is that better, everybody? Yeah. Stop filing your cases. That'd be nice if it wasn't the Department of Justice in charge of all of that. Okay, better. Okay, thank you so much. Yeah, everybody, you gotta tell me. I've got a couple screens, but I never really know, so let me know. All right, so those are our habeas cases here. Next, we have the mandamus that's been denied, or mandamus. Here we go. Undo, zoom out. I don't have a zoom on, so that's interesting. Would love to, but can't. All right, here we go. Robert Batson, Edward Greeman, Jack Carpenter, petitions for writ of mandamus are denied here. Next, we have In re Lyle Harrison. This is another form of papyrus, denied. Writ of mandamus is dismissed. Petitioner has, oh no, we have another one? Oh my gosh. All right, so this one again is going on into the red zone here. As petitioners repeatedly abuse the court's process, clerk's directed not to accept any further petitions. So this is a full order. They're saying we can't keep any. I wonder if it's because of the color. I've turned off everything I could possibly turn off here, because even when I go through and try to edit these lives, I myself am like, what the H is going on? So I don't know. It's just very frustrating. All right, so we've got number 2 here, Mr. Harrison. All right, here we are, page 6. And here's page 7. Justice Barrett took no part in consideration, so I guess she was busy. In re Samuel Rivera here, and then again we have another one denied. They're not going to, it's the autofocus. Yeah, I can't seem to be able to get rid of autofocus. All right, and then rehearings have been denied here. So we've got Watson, Atkinson, Boggs, McCoy, Robertson, L. Gomez, and Wood Jimenez here. All right, so here we go. Then that takes us into what the justices have disagreed about. All right, so if they denied cert, then or something along those lines, they may really be upset about it, and so they'll come in and write a dissent or something along those lines. So that's what we have here. So the first one, Chanel Nicholson versus W.L. York, Cover Girls et al. On petition for writ of cert, the U.S. Court of Appeals, Fifth Circuit. And this, they have denied cert, and Justice Jackson seems frustrated. So let's take a look here. The petition for writ of certiorari is denied. Jackson, with whom Sotomayor joins dissenting from the denial of certiorari. Nicholson claims that on numerous occasions between 2013 and 2021, she was barred from entering her workplace because of her race. Nicholson filed this lawsuit in 2021 alleging intentional race discrimination in violation of 42 section U.S. Code section 1981. According to Nicholson's complaint, the most recent instances of race discrimination occurred within the 4-year statute of limitations, but the Court of Appeals nonetheless concluded that these claims were time barred. In the panel's view, the more recent acts were merely the continued effects of prior instances of race-based exclusion and thus are not independently actionable. That holding flouts this court's clear precedents. We have long held that each discrete discriminatory act starts a new clock for filing challenges alleging the act, regardless of whether similar instances of discrimination have occurred in the past. And they're citing the Morgan case here. Because the Fifth Circuit's contrary ruling was patently erroneous, this court should have granted Nicholson's petition and summarily reversed the judgment. I respectfully dissent from the court's decision to do otherwise. All right, so this is a statute of limitations question regarding discrimination. So she's saying, I disagree here with how the statute of limitations was set out. All right, so we got that. And I won't go further here, but if you're interested in more details on that case, you can just pull this up as well. Here, so I think we probably have heard a little bit about that too. Some systems allow Zoom. Okay. Yeah, I've got to take a look and see. All right, and then again, I'm fast forwarding through this, everyone. Because we've done the synopsis of what she's basically stating here. All right. Okay. And then this is the big one, everybody. This is the big dissent in, oh wait, no, it's not. No, wait, is it? Yes, it is the big dissent. All right, hold on a minute. You know what, we've got two dissents. That's right. I was like, wait a minute, Thomas did a dissent. All right, so this is Kavanaugh's dissent in the Snope case. So this is the high capacity weapon case. It was a strip club that had race quotas. That's very interesting. Yowzers. I don't know about all of that business. All right, so here we go. This is one of the big Second Amendment cases here. So the petition for writ of cert is denied. Alito Gorsuch would grant the petition for a writ of certiorari. The statement of Justice Kavanaugh respecting the denial of certiorari. So we have Alito, Gorsuch, and Kavanaugh, and then of course Thomas has his. It's coming up next. So we have 4 justices that would have taken the case. Here we go. In the District of Columbia v. Heller, this court ruled that the Second Amendment must be interpreted in light of the constitutional text, history, and tradition. That's awful. The court further determined that the Second Amendment protects those weapons that are in common use by law-abiding citizens. Because guns's are in common use by law-abiding citizens, The court held the District of Columbia's ban on a hand GUN violated the Second Amendment. The court's later Second Amendment decisions in Bruin and Rahimi did not disturb the historically based common use test. Now, I've gone through both of those cases over time, but it's good to note the test here with respect to possession of particular weapons. And then here's Bruin and Rahimi. This case primarily concerns Maryland's ban on the AR-15, a semi-automatic rifle. Americans today possess an estimated 20 to 30 million AR. That's a lot. Let's pause for a minute. By the way, Maryland has the strictest statute set out regarding what's allowed and what's not allowed. Just so you know, they have the best one so far. Yes, I did. I've gone over Heller. I should probably do another one, but I don't know. All right, so 20 to 30 million and AR-15s are legal in 41 of the 50 states, meaning that the states such as, that is, sorry, wrong page. Such as Maryland that prohibit the AR-15s are something of an outlier, stating that AR-15s traditionally have been widely accepted as lawful possessions. So, but we shouldn't have accepted it. Okay, I'm sorry. Given the millions of Americans own AR-15s and that a significant majority of the states allow possession of those rifles, petitioners have a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected by the Second Amendment. If so, then the Fourth Circuit would have erred by holding that Maryland's ban on AR-15s comply with the Second Amendment. Yikes. So I think the other justices are like, we've got enough on our plates. We don't need to bring high capacity questions right now, I'm thinking. That's a crazy amount. Yeah, you're right. I know. But it's acceptable. So I just keep thinking like, okay, so if people start getting mini nukes, then is that okay? Like, they're like, well, every state allows for a mini nuke. This should be okay now. Like this, common use is a problem. I agree. Because people are, yeah. Under this court's Second Amendment precedents, moreover, it can be analytically different to distinguish the AR-15s at issue here from the handguns at issue in Heller. AR-15s are semi-automatic, but so too are most handguns. Semi-automatic handguns and rifles are distinct from automatic firearms such as M16 automatic rifle used by the military. Law-abiding citizens use both AR-15s and handguns for a variety of lawful purposes, including self-defense in the home. For their part, criminals use both AR-15s and handguns, as well as a variety of other lawful weapons and products in unlawful ways that threaten public safety. But handguns can be more easily carried and concealed than rifles, and handguns, not rifles, are used in the vast majority of murders and other violent crimes that individuals commit with guns in America. But aren't they? All right. In short, under this court's precedents, the Fourth Circuit's decision is questionable. Although the court today denies certiorari, a denial of certiorari does not mean that the court agrees with the lower court decision or that the issue is not worthy of review. The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other court of appeals. Great. And then he's citing the other cases here. Again, this is Kavanaugh. Opinions from other courts of appeals should assist this court's ultimate decision-making on the AR-15 issue. Additional petitions for certiorari will likely be before this court shortly, and in my view, this court should and presumably will address the AR-15 issue soon in the next term or two. Scary foreshadowing. All right, so that's Kavanaugh. Let's see what Thomas has to say about it. Egads, I think that things would go crazy right now if we put an AR-15 question in front of SCOTUS. I mean, we just can't do it right now. The timing's important. All right, Justice Thomas dissenting from the denial of certiorari. The state of Maryland prohibits ownership of AR-15s, the most popular civilian rifle in America. All right. This petition presents the question whether this ban's consistent with the Second Amendment. The Fourth Circuit held that it is, reasoning that AR-15s are not arms protected by the Second Amendment. I would grant certiorari to review this surprising conclusion. Surprising. Well, if you think about it, I mean, isn't that what they use for soldiers, right? All right, here we go. The Second Amendment guarantees the right of people to keep and bear arms. When raising a Second Amendment challenge, an individual has the initial burden of showing that the Second Amendment's plain text covers his conduct. Right. Once a challenger makes that showing, the Constitutional presumptively protects his conduct, and the burden shifts to the government to demonstrate that its regulation is consistent with this nation's historical tradition of firearm regulation. M4s, not AR. Okay, thank you, Mike. Oh, I appreciate that. I should probably go and do another seminar on the different kinds of weapons. It's been a while. It's been a while since I have gone in and studied the differences. I could probably educate myself a bit better for sure. Here we go. If the government fails to make that showing, the restriction must be deemed unconstitutional. It is difficult to see how Maryland's categorical prohibition on AR-15s passes muster under this framework. AR-15s are, well, I don't know about that. Hold on a minute. Let me check. Let me check the one that I have in my mind, that I see in my mind, and see which weapon it is. Okay. Hold on here a second. Sorry. Here we go. Okay. 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 Oh my goodness. All right, I was way off. I was thinking of an M16. Oh my goodness. All right, hold on. Let me pull up a picture here so that I've got a better idea. Okay. I got you now. I got you. Okay. Hold on, everybody. I think it's important to, know the deets of the stuff when you're talking about it. So, and I'm rusty. I'll be the first person to tell you that. Here we go. So, chambered. Okay. Here we go. Just real quick, everyone. I'm taking a peek. Is that okay? Hold on here just a minute. Developed by the Kalashnikov concern under RATKIF program. Oh, so it's Russian military service. When empty, full length. Okay, 37-inch barrel. Okay, standard magazine capacity of 30 rounds. Okay. Interesting. All right. Well, very good. Right, M16 was the basis for the AR-15. Well, I mean, honestly, I just don't know. I really need to educate myself better on this. All I see is a big gun, and I think, okay, well, you have 1.5 seconds, and then, the sheer quantity of bullets is what the issue is. Because you don't have enough time to run is the problem, right? So, yeah, I just don't know. Okay, by the special operation units okay, so it is special operations in the Russian military, but it is not the U.S. military weapon. So thank you so much. I appreciate that because that is something that I think is really important to note. Now, the other thing too, and I bring this up because I was on a live the other night where and someone, I can't remember his name, had said that in France there was a kid who is like a sports shooter, all right, And the sports shooter, like, he got a new weapon and people are all frustrated about it. So I want to make sure. Absolutely. Assault rifle means you can toggle between full auto and single fire and burst. Right, right. All right. So what I'm seeing here, and again, I will have to go further into it, but I just want to double check before I move forward so I've got the right picture in my mind. It's saying that it is a military assault rifle and not primarily designed for sporting and recreational use. Intended for military and law enforcement. Let me see. Sporting rifles, typically semi-automatic, designed for recreational shooting, target practice, or hunting. Often prioritize features like lightweight construction and accuracy, and ease of use in sporting context. Makes it unsuitable for many sporting activities where only semi-automatic. Okay, I got it. So I would say it could be a mix for sure. It could be a hybrid. Sporting would definitely be an option, is what I'm seeing here, but not necessarily primarily the goal. I think that's fair, right? 5.56 ammo is military grade, civilian use is 0.223. Okay, that's interesting. Okay, so right. M for guns. Okay. So, and I mean, if we think about it, right, and the more simplified, the better. Anytime you put an AK in front of a number at this point, we, those of us that aren't people that use those kinds of weapons, it's scary. It's scary. Just like, and then I try to explain it to people this way too. Like, just if you were to say biohazard, right? So if you put a sticker on something that says biohazard, I'm afraid I'm going to die from radiation poisoning. Now, you have to put biohazard on anything. It doesn't mean that there's nuclear waste in it, but that's what I'm going to think it is. All right? So if there's a barrel and it's got biohazard on it, I'm going to think that's nuclear waste. It could be maple syrup and have a biohazard sign on it for one reason or another because of the chemicals or how it was used. All right? Maybe it was the unused syrup like on a Sunday morning brunch, right? So it technically is a biohazard, but boom, I'm going to think it's nuclear waste. So you put an AK in front of a number, and I'm going to think someone's going to be going into a school, right? So I think that's an important point to remember. All right. Thank you very much for that moment. Let's jump back into it again. And of course, I will need to do more learning. All right, so Thomas, it's difficult to see how Maryland's categorical prohibition of AR-15s passes muster under this framework. Well, let's pop back up again. Right. So what did they say? Are we dealing with, they said semi-automatic, right? Let me just double check. I just want to make sure I have this right. Here we go. Yikes. Here we go. A semi-automatic rifle. So, but not all AR-15s are semi-automatic. Are they? AK has two different sizes. All right. It has a modern one similar, I think it's called, okay, right. Okay. Less power and accuracy. Semi-auto. Okay. So, as long as we've got, see, I just don't know enough, everybody, about the deets on it. I just can't tell exactly on here. Can be semi or full. Okay. But you could get a semi-automatic that could be a full automatic. Right. Oh my goodness gracious. All right, everybody. Whoo! That's the weakest link for me. I don't know how that stuff works. Right. All right. Well, let's get back here to the law where that I can understand. All right, here we go. So this was Kavanaugh. We're going to fast forward. So we are here in a biohazard land. AK is not the AR, okay? Yes, yeah. That's important distinction. Here we go. It's difficult to see how Maryland's categorical prohibition of AR-15s, I'm sorry, AR or AK. How about anything with an A? If you have an A and then another letter, then I'm going to be worried that I'm going to have a radiation poisoning, all right? And the AR-15s passes muster under this framework. Oh my gosh, to start, the AR-15s are clearly arms under the Second Amendment's plain text. And under Heller here, we held that the term arms in this context covers all weapons of offense or armor of defense. Explaining arms include anything that a man wears for his defense. What about a woman? Or takes into his hands or useth in wrath to cast at or strike another. What? Is this the Bible? What are we talking about? Thus, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. All right, that's another big piece. Just call it a semi-automatic rifle, high capacity. Okay, I got it. Right. All right, okay. Because AR-15s are arms, the burden shifts to Maryland to show that banning AR-15 is consistent with the nation's historical tradition of firearm regulations. You know, it's a valid question, right? We have to figure out how we're defining arms in order to walk through the Second Amendment analysis. One of the biggest things, of course, that Scalia said is that weapons of war are not arms, but then we have to sort out what's a weapon of war and what is not. So that's tough. I'm unaware of any historical regulation that would serve as a proper analog to Maryland's ban. Maryland invokes the historical tradition of prohibiting the carrying of dangerous and unusual weapons, right? Under this tradition, however, a weapon may not be banned unless it's both dangerous and unusual. Under Caetano, right, weapons in common use today for self-defense and other lawful purposes remain fully protected. Under Bruin, and AR-15s appear to fit neatly within that category of protected arms. Tens of millions of Americans own AR-15s, and the overwhelming majority of them do so for lawful purposes, including self-defense and target shooting. Okay. All right. Yeah. Yep. All right, fast forwarding. A prohibition of an entire class of arms that's overwhelmingly chosen by American society for these lawful purposes falls outside the government's power. Now, I'm going to take a moment and say I absolutely disagree with this so fundamentally that I find this sentence to be offensive. I found it offensive when I read it in Heller, and I find it offensive when it's quoted. Let's take a minute and look at this again. A prohibition of an entire class of arms that's overwhelmingly chosen by American society for these lawful purposes falls outside the government's power. So they are trusting that American society can make its own choices on what kind of weapons it wants. And for me, that seems blatantly not a good idea. That's a bad idea, genes, all right? Because American society doesn't always make very good choices. So this particular statement here, again, is very offensive because if it were allowed, American society would make even worse choices. The only reason why we have any kind of livelihood in this country is because there are some regulations that help the worst of the worst. So I'd have to say this one is very offensive if you wanted to know my opinion. There you go. History and tradition makes the whole thing. Oh my gosh, I know. History and tradition is like what was heard around the world. Thanks, Scalia, for nothing. Despite the foregoing, the Fourth Circuit upheld Maryland's ban on the ground that AR-15s are not constitutionally protected arms. Still many shops that sell. Right. So, and I think that's important. One of the I believe here, one of the first cases was in the 1930s, where they said, can people have a machine gun? So this was kind of like during the Al Capone era. And they said, no, I don't think so. They developed the quotes, offensive quotes are us. Ah, all right, that's funny. The court acknowledged that at first blush, it may appear that AR-15s fit comfortably within the term arms, but the court insisted more is required. Because the Second Amendment must be interpreted against its historical and legal backdrop, the Fourth Circuit held that the challengers also had to show that the right to possess AR-15s fall within the historical scope of the right to keep and bear arms. The challengers could not make this showing, in the court's view, because the Second Amendment does not protect the right to own dangerous and unusual weapons, including AR-15s. This reasoning is dubious at least twice over. The Fourth Circuit placed too high a burden on the challengers to show the Second Amendment presumptively protects their conduct. And its determination that AR-15s are dangerous and unusual does not withstand scrutiny. So I think, right? Oh my gosh. Right. Tea break, thank you. They are illegal if you don't, well, I mean, come on, right? The Second Amendment stuff is just, wow. Right. It's a lot. It's a lot, the Second Amendment stuff. I liked the days, I'm not going to lie to you, I preferred the days before the Second Amendment applied. All right, those were the good times. Did we have problems? Yes. But did we have to sort out the Heller test? No. And those were the good days. I appreciated that. I remember when Heller came out and McDonald. And when Heller came out, I was like, we're not going to deal with this. But when McDonald came out, I was like, oh my gosh, here we go. And then all of a sudden now we have to like deal with all of this rubbish. Yes, before the Second Amendment applied. So you didn't have any Second Amendment rights until 2008. Right. Or 2000, and then 2010 on the state level. All right. You didn't have it. You just didn't have it. So it wasn't until 2008, then we had to start teaching this crap. And it's confusing. All right, the Fourth Amendment urged by requiring the challengers to prove that the Second Amendment protects their right to own AR-15s, or in the terms of our Second Amendment jurisprudence, that their conduct falls outside the historical exceptions to the right to keep and bear arms. A challenger, Sears Magazine. Well, it's not about that, right? It's not about where you can get your weapons. You got to explain. Okay. Oh, all right. I'm sorry. All right. I just assume everybody's in my own mind when I'm saying stuff. All right. So here's the deal. Here's the 411 with the Second Amendment. All right. Right. We have two pieces to it, right? The arms, and then we have the militia. All right. The history is also, we have to go into something called the incorporation doctrine, and I'm not going to spend too much time on that. Incorporation doctrine. All right. So we had a case out of Maryland in the beginning. And in that case, it said the Bill of Rights doesn't apply to the states. So no state laws have to comply with the Bill of Rights. That's just what it is. All right. And then we had another case after the war that said, well, first we have a case called the slaughterhouse cases. We'll just use that. The slaughterhouse cases, and then later, multiple other cases that said, now we've got the 14th Amendment, and we're going to use that 14th Amendment to apply all of the Bill of Rights to the states. But we can only do that if we hear a case. So in 1930, let me get the exact citation for this case, just to make sure here. Because I always get this mixed up with the obscenity test, because the Miller test is also the obscenity test, and those are very different things. Let me just make sure here. must be Miller, 1939. Here we go. So the Miller case is 307 U.S. 174, 1939. All right. So here you go. This case was decided by the U.S. Supreme Court in 1939 and had to do with the Valentine's Day Massacre. All right, so the weapons used during that massacre were very upsetting that people had access to these weapons. So this case had to do with that kind of a weapon. So it went up to the U.S. Supreme Court and they said, our Second Amendment right allows for us to have that kind of a weapon. And the U.S. Supreme Court said, the Second Amendment does not apply to you. The Second Amendment is really about militias and only the federal government and militias. It's not about whether or not you can carry your weapons. That's not what that's not what the Second Amendment is about. It's about militia and how the federal government deals with militia. All right? That's the Miller case, 1939. And then in 2008 comes along a Heller case where they had put restrictions on handguns and who can carry, how they can carry in DC. All right. So DC set out a law. It said you can't have your handgun, whatever's. All right. You can't just be walking around with a handgun. All right. So this guy sued and was like, dude, I'm a cop. I got to take my weapon home with me. This is ridiculous. And the court's like, you're right. You're right. It is ridiculous. This is way too strict. And now the Second Amendment applies to the federal government. All right. That's what Scalia said. So then in 2019, McDonald's, I believe this was Chicago, was like, well, what about the states? The states have gun laws, and that's a pain in the keister. And so the Supreme Court said, you're right. The Second Amendment also applies to state law. All right. So now you have not only your militia question that was answered in Miller, but now this whole right to bear arms stuff now applies to you. So 2008 through Heller and 2010 through McDonald. Before that, whatever happens with the weapons happened. And if you were in a town that said no guns were allowed at all, that was constitutional at the time because you had no right to the Second Amendment. Were there towns like that? I have no idea, but it would be lawful. Or were there other towns that said you can have like a, little tiny gun, not a big, huge gun? Was that okay? Well, it depends on your town. They could do whatever they wanted. They could do whatever they wanted until the Heller case was decided. So Carmine, have you read Heller? That's the question. Have you read the Heller case? Right here, which is the case that's being cited over and over and over again here, is the Heller case. See right here? That's what Thomas is quoting. Okay. Well, what's unconstitutional? I don't know. That's debatable, Doughboy. Valid question, debatable. So anyway, the point is here, what I'm trying to say, all right, everybody, and I think the Second Amendment's an excellent use of trying to explain how the law actually works here, the whole mess. All right, well, hey, let me ask you this, Carmine. All right, everybody, hold on. Hold on to your britches, everybody. I'm going to ask Carmine a question. All right, are you ready? Oh, law school. All right, so here's my question for you, Carmine. If you're in state court and you are suing a bank, all right, your state bank, do you have a right to a jury trial? Do you have a right to a jury trial if you're suing a bank civilly? Let me ask you that. Do you? Yes or no? Yes or no? That law school is yes or no question, Carmine. Do you have a right to a jury if you're suing someone at the state level? No, you do not, Carmine. Holy crap. No, you do not. The Seventh Amendment does not apply to the states. Neither does due process out of the Fifth Amendment. And unless you're in the Second Circuit, neither does the Third Amendment. All right? Okay? So this is how I know you're not in law school, Carmine, because this is what we learn in constitutional law. And maybe you're just starting, but I would say you need to remember this. Trial by jury. All right, Carmine's on something, everybody. Let's keep moving. Here we go. So I talked about the incorporation doctrine. So that's what I'm saying when it comes to the Second Amendment and whether or not it applies. Again, some people had like had like cannons and stuff, right? And that was fine. But some towns said you couldn't. So the whole point here was that there was some kind of regulation that was allowed to be put into place after 2008. All right. So either regulation allowing it or not allowing it. That is all now because of the Heller case. All right. So I'm not saying it's good or bad. I'm just saying it was a heck of a lot easier when it wasn't applied, because then we didn't have to worry about going through all of these different tests. All right, here we go. Fourth Circuit erred by requiring the challengers to prove that the Second Amendment protects their right to own AR-15s, or in the terms of the Second Amendment, jurisprudence, that their conduct falls outside the historical exceptions to the right to keep and bear arms. A challenger, here we go, need only show that the plain text of the Second Amendment covers his conduct, which I think is fascinating, because the plain text is what we've been debating this whole time. What exactly is an arm, right? The plain text says the right to bear arms. And then this question of what is an arm is what we have to define. This burden is met if the law at issue regulates Americans' arm-bearing conduct. And this was Rahimi from last year. Once the challenger makes this initial showing, it's the government's burden to show a historical limit on the right to bear arms nevertheless justifies this regulation. The Fourth Circuit placed that burden of producing historical evidence on the wrong party. Okay, so Thomas is just saying that the burden should not be on the plaintiffs, but should be on the government. So he doesn't like who's got the burden here. Right. So our precedents make plain the Fourth Circuit's error. In Bruin, we had little difficulty determining that the plain text of the Second Amendment encompasses carrying handguns publicly for self-defense. We considered the historical limits on the right to bear arms only to determine whether the state had met its burden of proving that its regulation was historically justified. Likewise, in Rahimi, the court found that self-evident that a law prohibiting individuals subject to domestic violence restraining orders from possessing firearms regulates arm-bearing conduct. All right. Oh my gosh. Your patent bar exam. Oh, I'm so sorry. The court again considered historical limits only after shifting the burden of proof to the government. All right, so that's really interesting how we can, that's where his issue is. Who has to actually prove it here? If the bank's an actual state agency, it has sovereign immunity, but it's just a state chartered bank, you can sue for fraud and breach of contract. Listen up, Mike. The whole point was, I see where you come from. I got you. The whole point of my example was to make it so that no federal banks were involved. All right. So let me give you a different example. All right. Let me give you a different example. You trip and fall. You trip and fall at the Capitol of your state on the Capitol property. Let's just say you trip on the steps. And then you break your arm. And then you sue the state. Are you entitled to a jury? All right. That cleans it up a little bit better for you. It wasn't a great example using a bank. That was my bad. But that's what we're talking about here. I'm talking about only state situations. Now, what's important to note is that you're not entitled under the federal constitution, but your state may have added a jury trial for civil cases into its own constitution. So if your constitution, let's say you're in Massachusetts, is like, you have a right to a jury trial for a civil case, boom, there's your right. But it's not because of the federal constitution. See what I'm saying? That was my bad. That wasn't a really good example. All right, here we go. Back up. So the burden needs to switch. our precedents make plain the Fourth Circuit's error. In Bruin, we had little difficulty determining that the plain text of the Second Amendment encompasses carrying handguns publicly for self-defense. Considered historical limits on the right to bear arms, only to determine whether the state had met its burden of proving that its regulation was historically justified. So we had a state regulation, a state law in place here. Is that a life example? Just saying. Oh my goodness. Carmine, are you causing trouble? Oh my goodness gracious, everybody. All right, I'm fast forwarding here. Yowzas. Can't the feds preempt that? Not trying to be difficult. Preempt what? The bank? Preempt what? No, it's okay. It's all right. There's a difference between respectfully asking questions about something you'd like more information about and, being a jerk. And you are so far not in the jerk zone. I don't know about the Carmine person. Okay. Yeah. Decisions of fact, whatever. Right. So I'm not sure what you mean. Are you referring again to the bank's question here? Be easier if you're in a classroom, because then I could just have you explain it. Oh, I think everybody should have some credibility, right? Everyone needs credibility. If you don't have credibility, then, how am I supposed to believe you? Oh, you just ask questions. Oh, no, you're a bot. I'm curious. Yeah, no problem, Stephen. Yeah, no problem. I'm just not sure what you mean by preempt. Buddy, an insult. Oh, dear. My grandpa was a lawyer for like 60 years here in North Carolina, so I like the law stuff. It's interesting to me. I love that, Mike. I love that. I think that's fantastic. No jurisdiction gets bounced to federal. Okay. So, right. Again, I was just making a note of the difference between state versus federal, because at the federal level, if you want to sue at the federal level, you're in a different category under the Seventh Amendment. All right. That's what I'm trying to say. Is that some pieces of the Bill of Rights don't apply to the states yet because of the incorporation doctrine. Okay, I think Carmine's a bot, everybody. My gosh. All right, here we go. Back in it. We're in it to win it. Let's bring it home here. We're in it to win it. All right, skipping. Here we go. The Fourth Circuit separately erred in determining, I want tacos now, that the AR-15s fall within the historical exception for dangerous and unusual weapons. A weapon may not be banned under this principle unless it is both dangerous and unusual. That's the Katano case. Weapons in common use today are for self-defense, are fully protected. That's really the question. Can you sue the state twice, both in state and federal court? Is it double jeopardy? Great question. We have two different roads to go down. So you could sue, let me think of an example that doesn't involve a bank, right? So hold on here. I'm looking something up real quick just to make sure. All right. Okay. So let's say that you have been taken by the state troopers and put into the basement of the Capitol. All right. So we've got false imprisonment. It's incorrect. It wasn't a crime, but you're suing them. All right. Now, while you were there for 2 hours, the troopers were like, whoopsie, we made a mistake. And then the FBI came in and said, that's all right, we'll take them. So then the FBI took them to the federal courthouse and put you in the basement there for 2 hours. All right. So you can sue the state for false imprisonment. You can sue the FBI for false imprisonment under the federal statute. But if you have a crossover between a federal and a state claim, like it's a federal, the big claim is federal versus the state claim, you're probably going to want to take it to federal court. But that's where the line comes don't make it, not everything's a federal case, comes from whether or not to sue in federal court or civil court. In this situation, you can do both. You're right, Mike. Yes. Sue everybody. You absolutely can. Absolutely can in this, with this scenario. All right. So this part also, I do not really agree, is far more serious for more damages. Yeah, it's possible to get more damages from the federal government because I think the limitations on verdicts are different at the federal level. But federal cases just are much more, they're much more elegant, I guess. There's more rules, there's more pomp and circumstance to them than the state cases. Like the state cases are more like, you know, in the trenches versus the federal case where it's like, yo, here we are, come on in, you know, it's very formal. Can charge you on the same drug. Yeah, that's true. Right, exactly. But if you get charged on a state and a federal crime, both of those crimes, the state's going to be like, here you go, feds. We got enough. We got enough on our plate. We don't need any more. All right. Our Constitution allows the American people, not the government, to decide which weapons are useful for self-defense. Now, I'm not sure I agree with that, everybody. Let me ask, held in state jail on an ICE hold. Ooh, that's a great one. That's a great one. Example. Absolutely. So, but let's ask this question here. Who should decide which weapons are for self-defense? Should the American people decide? Or should the government decide what self-defense weapons are? I'm just curious. Here, weapons, self-weapons. The people. Okay. The people. I feel safer owning a tank. Oh my goodness. Yikes. Second Amendment has always been about the people. Well, technically, it's only been about the people, though, since 2008. So it's still new. And the reason I bring this up is because it's like a baby amendment, and we're having to fill in what the proper regulations are and how to properly use the Second Amendment because it's so young. I live in a tank, so I'm good. That is my house, the tank. The tank is my home. But I think this is a really good question, right? Do we say to the people, like, you know best, this is a right that's been given to you, so to speak, the right to bear arms, right to bear arms. Does that mean you get to decide what the self-defense weapon is or not? Oh, thanks, Stephen. No, right. Government of the people, by the people, and for the people, making them one of the same. That's the question. That's what I had. That's kind of the point here. The people, right, are deciding what it is, but the people are the government. The government are the people, and the people are the government. That's why things get mixed up, right? So because we're not sure, we're like, we want the government to make it so that as a society we can be relatively safe overall, and not violating constitutional rights. And if we just have the people decide whatever they want, it's like, what are we doing? I'm saying the founders put that in because of England. So it's more about the people's right to defend against tyranny. So I think the people should have the right to decide. I think that's a great argument. I think that's an excellent argument. Oh my goodness gracious. In Texas, right, they try federal and state. Yes, that makes sense. The people didn't write the Constitution. That's a good point too. Who needs a tiny house when you can live in a tank? I love living in a tank. But like that one state Supreme Court recently overriding pro-choice that was voted on by the people. Oh my gosh, Allison, I think that was Missouri. Was that Missouri? Right? That raises so many more questions then, doesn't it? If the people are supposed to make these decisions, then does that mean the court can take that choice from them? I think that's a good question. Yeah. Valid question. Most people aren't trained lawyers. True. They most certainly are not, and nor should they be, because we've got plenty of lawyers here. If we're going all history and tradition, the people should have the right. Well, and that's what Scalia said. with his history and tradition test that he set out in Heller, right? Yeah, I agree. Misery. That's all right. Right, misery. Oh my goodness, that's funny. Yeah, no, I mean, again, and the one of the biggest issues with the Second Amendment is figuring out how it actually works, because it's only been on the books for 20 years, less than that. Uh, Less than 20 years, 15 years. It's only been on the books for 15 years. 15 years old. So it's just a little teenager. So how it works is still being determined. And because of that, there's lots of debate going on regarding it. People only vote, we aren't qualified. Well, I don't know. They knew it would happen. Oh, yikes. Yowzas. Yeah, it's frustrating. Constitution does start with we the people. True, it starts with we the people, but the problem is at the time, people were not the people that are today. So we the people's changed. The people changed. Now, people then had certain things that they could do, but there were a lot of non-people that were actually also in the country, like women and various other people. And they weren't considered people. They weren't the people. That's the problem. Yeah, case law and precedents. Yes, it's got to work together. But what's so great about we the people is that it's okay for the people to change because it still holds true. Even now that we're recognized, women, for example, as people, we're actually people now, not property, then now it works for us too. Argument that it's about democracy, right. Old law that said the Senate feels against best interests. They can, well, right, and they're going to play that game a lot. They're dinking around with all of that stuff. The people who wrote the Constitution were written by the best and the brightest. Well, I mean, I don't know. They were written by the people who had the power to get together in a room and talk about stuff. You know, I like to put it to people this way. Like if there was a blacksmith in your village, in your colony area, you've got blacksmiths going to take 3 months off in the summer and go to Philadelphia? No. Why? Because the town needs the blacksmith to do his job. These fellas that all sat around, don't get me wrong, I'm grateful, and were dinking around with forming a government, drinking the wine and doing the hashish for months because they were able to, because they weren't critical to the actual livelihood of the village. All right, there, I said it. Right, they couldn't leave. In my opinion, the most critical people, the absolute most critical people in the colonies were the ones who would not be able to just get up and leave for 3 months. That's how I see it. Not that they're not incredibly intelligent, especially John Hancock. Hashtag I adore John Hancock, all right? But I'm just saying. I'm just saying here. All right, fast forwarding. So that was my question here. Again, is it the American people or the government? And then that's a great question. Like what people, because the government's of the people, right? So that's why that question gets a little janked up when we talk about it. Right. And if there's definitive dates, could one cite later laws as necessary as progression and thus in line with the history and tradition? Well, that's what they do argue. They argue it every time history and tradition comes into play. That's exactly right. Yeah, I know, the metric. I'm not good with the metrics. History and tradition, right. Oh my gosh, VC, yes, exactly. All right, let's fast forward here to Thomas's last piece, all right? Thanks everybody for chatting with me though. I think this is a really good discussion for us to talk about, right? We can figure out different ways of going around it. Oh, sorry, Doughboy. My bad. Your questions are like two-parters, man. That's my bad. Will not be right. Well, you can technically. You can actually be silenced. I don't mean to rain on your parade, but here we go. All right. When does English common law no longer become applicable when making arguments? Okay, I got it. English common law no longer become applicable. I think English common law, all right, will always be a reference. I think it will always be a reference, just like the Federalist Papers are a reference. The Anti-Federalist Papers are references. Sometimes we even go back all the way to Rome. We go back all the way to Greece sometimes. I think all of these are a mishmash that we use to support what we're saying. Oh, here it is. I was like, where's my book? So we just use these as resources, and that's how Madison did it when he wrote the Constitution. So, all of the different things that he looked at were here's Madison, what he used in order to put together the government. So that's why we use it as well. References. It's not supposed to be used as, definitive precedent that we can argue on. Like, well, in England, they did this. Like, no, it's supposed to be a reference. It's not supposed to be your entire argument. So it's support. It's extra information. Like I could cite an English law to explain why I think the order of the words of something is very important, right? But it doesn't mean necessarily that I'm going to win if there is actual U.S. precedent, U.S. case law that supports the other side. Doesn't mean anything anymore with statutes now. Well, perhaps. We had a discussion with Legal Dad I don't know, it's probably been a year ago now. Time means something different to everyone. A lot of people, I would say common law is case law. Now, he would say common law is old school law. All right, so common law, no case law these days is common law. I would disagree with that. So it's kind of an ongoing legal argument. Cicero, yes, exactly. Tony Blair, I don't know. It's a good question. Valid question. Here we go. Let's bring it home. Let's bring it home. Here we are. I would not wait to decide whether the government can ban the most popular rifle in America. That's pretty harsh. That's a pretty harsh sentence here. Ooh, victimless crimes. Oh my gosh. I agree. Whether the government can ban, right? That question is of critical importance to tens of millions of law-abiding AR-15 owners throughout the country. And further, percolation is of little value when lower courts in the jurisdictions that ban AR-15s appear bent on distorting this court's Second Amendment precedents. This percolation issue is something that's been hitting the courts really hard, especially in the birthright citizenship case that was argued in front of the U.S. Supreme Court. This word percolation was used over and over and over again. So Thomas needs to chill out, man. All right. And fast forwarding. I doubt we would sit idly by if lower courts were to subvert our precedents involving any other constitutional right until we are vigilant in enforcing it. The right to bear arms will remain a second-class right. And we're citing McDonald because you have to. You have to cite Heller and McDonald. That just has to be done. The constitutional status of AR-15s is all the more urgent after this court's decision in Bondi v. Vanderstock. Recently amended regulations of the Bureau of, ATF, provide that a firearm under the Gun Control Act includes objects that may readily be completed, assembled, restored, or otherwise converted to working firearms. So this would be the ghost gun case, right? Which I don't have all the ins and outs of that. In Vanderstock, the court refused to hold that definition unlawful, reasoning that an artifact noun, that is a word for a thing created by humans, may refer to an unfinished object, unless that weapon parts kits are as regulable as the firearms they might eventually become. Yikes. Every single AR-15 can be converted to a machine gun using cheap, flimsy pieces of metal, including coat hangers. Thus, on the course logic, it seems that the ATF could at any time declare AR-15s to be machine guns prohibited by federal law. Until we resolve whether the Second Amendment forecloses that possibility, law-abiding AR-15 owners must rely on the goodwill of a federal agency to retain their means of self-defense. That's no constitutional guarantee at all. Like, this is so frustrating. I respectfully dissent. This is frustrating. Anytime I read Thomas, I get frustrated. So, all right. So there you go, everybody. We had nothing here but the highest qualities as I drag all my papers back. There we go. That's what's happened on the Supreme Court just yesterday here. This is just yesterday, Willie B. So the dissent there isn't for a full decision. The court decided which cases they were going to grant cert on and which ones they denied cert. And they had denied cert on the Snopes case. And so Kavanaugh and Thomas wrote dissents stating that they had wanted the court to take those cases. Sure, of course. All right, here we go. You should have seen me try to show how you can get an AR automatic. Couldn't even, really? That's interesting. That's very interesting. Yeah, I don't know all the ins and outs of that stuff. I'm more of a, whip person, or a baseball bat. I mean, lately it's been a whip. So, this is kind of outside of my wheelhouse here. But it's what my preference is. My self-defense preference is different than others, and I recognize that. Some pink highlighter horns. My gosh, I don't know. I promised myself I wouldn't draw on this particular Supreme Court picture. I put the little labels on there and I made a note like, don't draw on them this time. Double tap. Yes, that's right. Double tap. Thank you so much, everybody. Well, hopefully this gives you a little insight into what's going on with the Supreme Court. We're going to hear a lot about the Supreme Court over the next few weeks. Because again, this is when all their decisions need to come down. We have to get all of them because they can't leave. Basically, they can't leave until all the decisions come out. But again, this summer is going to be bonkers because they're going to have to come back in on that shadow docket because of how this administration's running. Yes, yeah, katanas and swords. Also, excellent choices. Excellent, Navy vet. Excellent. I need something that's a little further away. That's why I prefer a whip, but a bat does a good job as well. Protruding through, yes. Summertime's when they declare. Well, we'll see. We'll see what happens. Thomas is going to be riding around in his RV with his lady friend. And they're going to be going around and then getting called back in. Oh, there you go. Exactly. I think you need a far away reach weapon and a close up. The other thing too that works is just to not be in a place where that's going to happen. So typically, if I feel like I'm in a place where I may need a weapon, it's like, I got to go. Like a backlog. It is. Or, their shadow docket just means that cases haven't been pre-approved for this session. So it's also called the emergency docket too. So, right. Well, we'll see what happens. We'll see what happens with that. Well, hopefully tonight, everyone, this was a good insight for you, that you learned something new, and we have some great debates, great chats here. I'm always thankful for the time that you all come and spend with me. I learned so much. I appreciate that each and every time. Right. To decide whether or not they'll take it. Yes. So with that, I will go ahead and sign off. I am doing lots of lives over on the TikTok if we've got breaking news, which we should actually have something new in the Abrego Garcia case tomorrow for those following. But this should be a busy week actually for Garcia. We'll have that going and I'll do lives there, but I'm always here on Tuesday nights, everybody. Always here over on the tube. If you want a good laugh, go watch Walter. Really? About writing the Constitution. Okay, I will. Yes, the ARAK. I'm just, whatever. If it has an A, I'm worried. Yes, thank you all for coming, everyone. Thank you very much. I appreciate your time. I wish you all the best. Take care, and I will see you again next Tuesday. So have a good one.